You're ready.
Appellant, and Madam Clerk, would you call the next case then, this case?
Re Layton W.
For the appellant?
For the appellant, Nikki Hall, Your Honor, from Franklin County Bar.
And Ms. Hall, before you proceed, would you let us know how much time you're reserving?
Yes, Your Honor. Yes, Your Honor. 3 minutes, please.
Thank you. You may proceed then.
Thank you, Your Honor. If it pleases the court, I am Mickey Hall from the Franklin County Bar, and I represent the father in this termination case, who's the appellant. The child was born May the 20th, 2015, so he's just a little over 5 years old now. And if I can get immediately to the crux of our belief in what this case is, it's a best interest case. Of course,
you can argue this case. This is your argument, so you present it.
Thank you, Your Honor. Of course, there are statutory requirements plus the best interest case, and at the trial of this matter, we did concede the statutory requirements were met. Mr. Walls is in prison and is not able to be a parent right now, so, and he has a sentence long enough to meet the statutory requirements. However, it's important to note that the best interest of the child must be met, and in particular, the analysis of the case has to be from the perspective of the child. From the perspective of the child, we would argue that his best interest is in maintaining that relationship with the father and the father side of the family. I think that's an important aspect to this case.
Mr. Hall, if I may interrupt you for a moment. There's an issue that neither side has raised, and that is that in the trial court's order, he of course goes through the factors for termination, and then when he talks about the best interest analysis, the statute that he cites is 36-6-106, which is not the best interest statute in a termination case. That is a statute that deals with determining custody when you have an annulment, a divorce, or another proceeding like that. So given that I think that's an issue that frankly might buttress your argument, is that the trial court didn't cite the right statute, and given that there is no walkthrough of all of the specific factors, it would kind of be hard for us to review his findings and say that yes, his findings are correct, given that the statute cited is incorrect.
Thank you for pointing that out, Your Honor. Yes, I would agree that would be an argument in our favor. And that also, I think in the brief that we prepared, we did point out that the judge really just had a cursory mention of the best interest factors, whether or not the statute cited was correct or not, in comparison to, say, the case we cited, Re Colton, I believe it was, where that court went through an extensive analysis, and there are 9 factors. And of course, the case law says that any other pertinent factors that can be brought up. The court just says, I've considered them, and they are in favor of the appellee in this case. So I would argue that that is a clear error that this court could rule on in that way. So, Your Honor, I guess continuing on, if there's no other question on that, this was an unmarried couple. I know you read the brief and know that the relationship did not last long. The father in this case had to almost immediately go to court, go to juvenile court, try to fight for his rights to see the child on a reasonable basis. And that continued over several court hearings until they finally got to a situation where he was seeing the child 3 days a week and the mother was having the child for 4 days a week. It's important to note that in his petition, the father made the allegation that the mother did not want him to see the child, in large part because he had another son who was just 7 months older than this son. And there was a resentment or something that, some reason she did not want that to happen. That is important because later on in the trial, the testimony was that by that time, Mr. Walls had been in prison. The mother was in complete control of the child's time with whoever. And even though she and the stepfather, she's married by this time, both said that it's important to maintain family relationships with all family members, they admitted that it had been over a year at that point that he had not seen either of those the siblings, in addition to the grandfather, the aunt, and so on. And the father, after he had gotten some shared custody, had raised one child, that older brother, as a single parent, had those 3 days a week with this child and also time with his older daughter. So these were important relationships. And I think the testimony at trial lends credibility to his earlier allegation that the mother was not sincere in fostering those other relationships, which she admitted, and I think is common sense, we all believe are important. That's, I think, a critical element of the best interest of the child from the perspective of that child. That child, has family members that, as the father testified, are very close to him and would be a meaningful part of his life. The testimony also from an aunt at trial was that the father, during this time that he was parenting the children, was a good father. Now, he admitted, and he certainly had to admit during the trial, he did mess up. He got into trouble again. He is in prison, and he admitted those mistakes and asked the court if he could, in spite of those, still remain to be a parent, because he thought, not only for his own wishes, but he thought that for his child, it would be very important, because his child was losing not only that father-son relationship, but also the entire side of that family was cut off to that child, and he felt that was important. And I think the case law says that's important. I think we cited in Re Dominique LH, in Re Adeline S, as support for maintaining those close relationships, not just with a parent, but also with other family members that you would normally be close to. Another issue, and has already touched on the fact that those factors were not really adequately addressed by the trial court. But there's another issue, and that is that this is a drastic step when you take a child from a parent, and in this case, all the other parents' family members as well. That is a final action, and that it needs to be an action of last resort. In my looking at this case, this seems to be an action of first resort taken by this mother. She was married for 3 months when this petition got filed to terminate those rights. At the time of the hearing, I think maybe they had been married about a year or so, the mother and the new husband. But in contrast to some cases where a child needs to be placed and needs to have some finality, this child was in a safe place where he was cared for. There at that point was no reason to take this drastic step of terminating all rights. I asked both the mother and the stepfather at trial, and it might have appeared to be foolish, and maybe it was foolish, but I asked them, is this going to change the way that you parent this child? if you lose? And they each said no, that the mother said the stepfather would be the same, and she, of course, would be the same. Stepfather said he would be the same. There was no urgency to terminate rights and reduce the number of people in this child's life that loves him. At that point, there was just no reason to take the drastic step right off the bat. Your Honors, for this reason, I would ask that you reverse the trial court's decision. Looking at the case from the child's, for the child's best interest, looking at the case from the child's perspective, this child is going to be denied family relationships that he would normally have. And there was no reason at this early point in time to have taken that drastic step. And I've got about a minute or so left. I will end on that and then reserve my time if there's any other questions.
Let me ask you, how long will it be before he is eligible for parole or probation?
He believes 2021, next year.
Thank you very much, sir.
Thank you, Your Honor.
Yes, sir. Father Alkali.
Good morning, Your Honor. Bradley Sherman from the Franklin County Bar.
Yes, sir.
Your Honor, I represent Brittany Dixon and her husband, Josh Dixon. They have a little boy that is Mrs. Dixon's with Mr. Dustin Walls. A young man's Layton Walls, and that's what we're here about today. I will try to do the court same courtesy of jumping right into the matter. I believe Mickey has boiled this down to the single issue of whether the court erred in finding that termination was in the child's best interest. Of course, the appellee's position is that termination of the father's rights absolutely is in the child's best interest. And to address some of the points that Mr. Hall raised, and I call him Mickey because I know him so well, but to address some of the points opposing counsel made, I think when Your Honors review this case, you have to think about the way you perceive the discussion of these relationships. You heard a lot this morning and in reviewing the record in this case about meaningful relationships with these collateral relatives and these half siblings. And I don't mean to treat the matter flippantly in the way that I'm referring to them, because these family relationships can matter. But I want the court to keep in mind in thinking about the case that you have to, I mentioned this in my closing argument, you have to sort of compress the time frame with which you're thinking about this. These are not children that grew up and spent years in close proximity to one another, spent a long time playing together, going to summer camp, going to kindergarten together, and all those sorts of things. At the time when Mr.
Sherman,
Walls,
I'm sorry to interrupt you. Before you get too far into the substantive argument about best interest, my immediate concern is what I addressed with Mr. Hall, and that is the fact that in its order, the trial court did not cite the correct statute for best interest analysis. So my concern is, how can we review that issue? It would be one thing if he had gone through each of the statutory factors, and then we might be able to say, well, the citation to the incorrect statute was clearly a typographical error because he's using the language and using the factors in the correct statute. But given that we don't have that, how do we address that on appeal?
Thank you, Your Honor. I appreciate the question. Obviously, I can't presume to know what the trial judge was thinking in the drafting of his order, but I can say that it's entirely possible that he was referring to Title 37-147. This is termination of parental rights. Part B states specifically that upon entering an order to terminate parental or guardian rights to a child, the court shall award guardianship or partial guardianship of the child as provided in the relevant Title 36, Chapter 1, Part 1. The effect of the court's order terminating parental or guardianship rights shall be provided as in 36-1-113. the best answer that I can give to your Honor's question is that perhaps the trial judge was incorporating that 36.6 or 36.1.103 by reference. He's alluding back to this 37.1.147. I think ultimately that's a determination that your Honors will have to make. Obviously, at this point, I wish it were spelled out otherwise in the order. But if you will look at the statute that he's actually citing that is referred to in Title 37, or child welfare laws there, it does delineate all of those best interest factors, 1 through 15, that a court can consider when awarding custody or guardianship. So that's I hope that addresses your Honor's question as best as I can come up with this morning. I wish I had him here to ask him. With regard to Mr. Hall's argument, what I was saying, your Honors, was that these children are all very young. When the father went to the penitentiary, I believe he entered the judgment orders that sentenced him to the 12-year sentence on April the 20th, 2018 in the Circuit Court of Moore County. What is also in the record is that he was already in the recovery court program in Franklin County. There's a series of sanctions and other guilty pleas and judgment orders and things like that in Franklin County. All that coalesced and came together on April the 20th, 2018, and that's what sent the gentleman to the penitentiary. So I guess knowing that it wouldn't do much good to argue that he was not, in fact, in the penitentiary, and in the interest of judicial economy, he did stipulate to the grounds for termination. So that first prong of the two-prong test had been met at that point. The court then moved on to concern itself with all the testimony of the available witnesses about what's in the child's best interest to do. Now, opposing counsel has made an argument. I understand the argument. I'd like to think I would have made the same argument, but in addressing it, I will simply say that this gentleman, Mr. Walls, had 3 children by 3 different women. My client and her husband testified in the trial, and I'll just refer your Honors to the transcript here, if you'll permit me to refresh your memories. Basically, that the half siblings were having contact with one another on a semi-regular basis, owing in part to the fact that Mr. Walls was getting regular parenting time through the Franklin County Juvenile Court. Of course, it makes sense that when Layton is with his father on his court-awarded time, that he would get to see those 2 half-siblings. Keep in mind, this is a child that is 2 years old or less while this is going on. So to my original point, which I eventually will get around to making, I don't know that you can characterize these as meaningful relationships in the way that you might in, for example, a DCS case where there's some danger that teenage siblings are going to be split up. You know, your Honors, I'm sure, have seen cases, as myself and Mr. Hall have, where you might have 2 siblings come from the same home. One has a behavioral problem. The child is more difficult to find a pre-adoptive placement for than a child that does have a sibling that doesn't have those same behavioral problems. I think if that were the case here, and I believe that's the case in one of the cases that Mr. Hall cited, it'd be a totally different analysis. But there's nothing in this record to suggest that my client, Ms. Dixon, and her husband, Mr. Dixon, ever did anything to purposefully undermine the relationship that this child would have with his half-siblings, keeping in mind that that relationship, based on their ages alone, required adults to do all the coordinating, transportation, get in touch with each other, look at each other's schedules. And I spoke to this in my closing argument, your Honors. It takes a fair amount of logistics to get, I'll say I'm a parent of 1 child, and I think sometimes I have a hard time getting him where he needs to be on time when it's just me and him. If you have 3 children with essentially 3 separate families, because keep in mind you have the father, his grandfather, who's spoken about in the transcript, another child, a sister that's a fair amount older with another young woman, and then a half brother that is in the father's home sometimes. Logistically, that's difficult to arrange, particularly when the father's had to come out, go to prison. He's not in that home. And to Judge McClarty's point, I checked on this the other day. He's still in Hardeman County, and I believe his next parole eligibility hearing is April of 2021. And I just did that through e-Thomas, Your Honor. So just to address that point, you have a grandfather and an aunt that have the young boy Jace, who's a half brother that's like 7 months older, and then another mother that has the young lady Amelia, and then my clients, Mr. and Mrs. Dixon, who are living together, bought a house together, raising Layton together, and have just had a half sibling of their own for Layton. They've had their first child together. So in the transcript, I asked my client, am I understanding your testimony that to the extent that the half siblings have not been able to contact one another, you are attributing it just to problems coordinating and communicating with that other side of the family? And Mrs. Dixon said yes, which I said, okay, so you have not purposefully said you will never see this child, he's mine, or anything of that sort. She said, no, you haven't told Dustin that he's made his bed, he can lay in it, anything like that. Ms. Dixon said no. Okay, and in fact, even in some of our discussion during the recess here today, you've indicated that you'd be willing to try and coordinate with Monty, who is Layton's paternal grandfather, to allow for Dustin to see his, to allow for Layton, to see his half siblings. And Mrs. Dixon said yes. And I asked her, do you believe that's important for him to have those kinds of relationships with those children? She said, definitely. But I said, in fairness to those involved, certainly you and Mr. Dixon, because you're both working full-time jobs and you're trying to get Layton back and forth to daycare and Bible school and those sorts of things. She said, yes, we're on different shifts. And I asked her, would you imagine that you would, I said, you would imagine you wouldn't want the sole responsibility for making that happen. Meaning, Your Honors, Mrs. Dixon wouldn't want to be solely responsible for taking Layton to the paternal grandfathers or to the half sisters with a woman that she's not friends with and doesn't have any familial relationship with, reaching out to these people and trying to line all this up. So I said, okay, I would imagine that you would not want to be solely responsible for making that happen. You all would expect that the other people would work with you and with your schedules too. Is that fair? And she said, yes. Okay, so that is the portion of the conversation to which Mr. Hall is alluding. And he essentially asked the same thing in his cross-examination. Nobody's disputing that it would be perfectly fine, for the child to have contact with his half siblings. My clients have certainly never denied contact with the half siblings. I will say that when it comes to trying to coordinate all this sort of stuff, it's characteristic of the sort of resistance with which the mother was met. When Your Honors look at the end of this case, the end of this transcript, the paternal grandfather who was called to court that day as a witness to speak on behalf of his incarcerated son didn't stick around for the proceeding. He left about halfway through, and when called to be a witness was nowhere to be found, had left the courtroom and left the premises for whatever reason. I can't speak to that, but my clients have consistently maintained that even though Dustin is in prison, they allowed Layton to see these other sort of ancillary collateral family members. And when they got married, my client, Miss Dixon, testified that she got a new phone plan with her husband, and that Mr. Walls's aunt, who did testify on his behalf, was actually contacting her through Facebook Messenger, and they were contacting that way. They just never could coordinate or work it out. So what I'm suggesting, Your Honors, is that I don't think it would be appropriate for you to overturn this case solely on the basis of Mr. Hall's argument that the relationships with these half siblings that the child knew when he was 2 years old or less are somehow going to be severed. Those people still live in the community. They're still able to have contact with my client. My client's still able to have contact with them. Everybody's got cell phones. Everybody's got Facebook Messenger. There's nothing in the record. And I think that's the most important part. There's nothing in the record to suggest that my client or her husband ever withheld this child from his father's side of the family. To the contrary, they testify that they specifically worked to set up sometime, but that just sort of stopped happening. I think that's the way life can go sometimes. Those relationships can exist even with Mr. Walls in prison at a bare minimum until the middle of next year. So I'm asking Your Honor to uphold Judge Angel's decision, uphold his ruling, affirm his decision, and allow this young man to be adopted by his stepfather, because now he's another year older. He's over 5 years old now. He was right at 4 years old when we had our trial. He's living with his mom and his stepdad. They've got a new house that they've bought together, and they've got another child in the home. And I would suggest that that relationship is certainly important, because unlike the half brother and half sister, he's growing up in the same household with his new baby sibling. On that basis, Your Honor, I believe that it is in the child's best interest. All the other things that a court looks to, stability, permanency, the ability of a parent to provide for necessary and appropriate supervision for a child, food, shelter, all that sort of thing. All of those things were addressed in court, and all of those things were addressed certainly to my client's satisfaction in Judge Angel's ruling, because he specifically referred to that statute 36-1-103 that is referred to in 37-1-147, the termination of parental rights statute. And he specifically said that every one of those factors inures to the benefit of the child being with the mother, being adopted by the stepfather, and terminating Mr. Walls' rights. So with that being said, I'll sort of yield back to Paul. I know I've got a few seconds there.
Thank you very much.
Thank you, Your Honor.
Mr. Hall, your rebuttal. Let's see, Mr. Hall, you're not coming through.
There, I'm sorry. Took for a minute for that icon to come up. Your Honors, I would say that the record does have something to say about the destruction of those relationships. In the transcript, both the mother and the stepfather said, yes, it's been over a year since Layton has seen his brother and his sister, not to mention anybody else. The mother was the one in charge. In 13 months or whatever it was, there could have been a way to figure out the cell phones and the Facebooks and everything else if the one in charge wanted it to happen. It's consistent with the original petition in juvenile court that the father filed, saying that she wants to keep the child away from the other children. And contrary to what she and her husband both said was good for the child, and what I think we all recognize is good for the child. I'd also say that it doesn't matter what age the children are or were. These children are brother and sister, and that's important. Whether they had a little time, they had a good year and a half probably together. It doesn't matter that they're not teenagers. They're brothers and sisters. That's an important relationship for the state to protect if it needs to protect it, and I would argue that it does. Also, in relation to the problem with the missing or in the incorrect statute cited, I would agree with Your Honor that is a problem, and exactly for what you pointed out. Had Judge Angel gone ahead and said, this factor is ruled on this way because of these things, and gone through the 9 of them or several of them, but all he did was this cursory reflection of, I considered them all, they're all in favor of the mother, that's it. I would argue that wouldn't be good enough if he had acknowledged the correct statute. But in this case, this court does not have the certainty of his reasoning. Final thing I would say, and I know this is something that everybody knows, but when I came across it in my research, I thought this says it better than anything else, and it's the United States Supreme Court, and I think I cited it in my brief. The MLB case, it said there is no graver consequence in taking a civil action than to sever family ties irretrievably. And I think that is what is done. Instead of a last resort, this has been a first resort. This should not be allowed to stand. Thank you, Your Honor.
Thank you. Thank you both. You
Thank you.
presented fine arguments. Thank you both.
Thank you, judges. Thank you, Mr. Sherman.
The attorneys may be excused.
Thank you.
Madam Clerk, will you recess court until our next docket at 1 o'clock this afternoon?
This honorable court is in recess until 1 p.m.
Thank you very much. And